I see that you're a little bit tired of this right now.
I am.
And one of the issues here is this case being dragged out unnecessarily. That the judge knows what the judge ordered, and I would request that the court prepares the order.
All right. So that is, unfortunately, I do agree with Ms. Alda here. I feel that counsel has proven themselves incapable of doing this together. So I will, the court will prepare the order.
A781255 Kurt Harris versus Ernest Del Casal. State your appearance for the record, please.
Good morning, Your Honor. Kurt Harris on behalf of the plaintiffs.
Well, Your Honor, this is Attorney Al Needham here for Defendant Del Casal.
Good morning, Judge. This is Alda Anderson on behalf of Defendant Michael Franklin.
Okay. All right, counsel. So, I'll just note for the record, it's so disappointing that when the council can't get an order together and agreed upon. I understand there's disputes as to whether or not any of these orders were provided for review and filing before they were actually entered by the court. The court has reviewed the orders and found that they do correlate very well with what the judges said at the different hearings. The court, the hearing on November of 2022 was with Judge Jones, and then in January it was with Judge Bixler, and then in February it was with Judge Cherry, and all of those judges entered orders. I do have some questions about this, if I could just understand, and I think Mr. Harris would be the right person to ask, or the person represent. Mr. Harris, are you online, or is your attorney?
Yes, Your Honor.
Representing yourself?
Yeah, yes, Your Honor.
Did you make offers of judgment in this case?
Yeah, we made offers of judgment, Your Honor. They were not enforced due to there was a component for an injunctive component in the offers, and so the Judge Jones did not utilize the offers of judgment.
Okay. So the next question I have is, on your understanding, Mr. Harris, what was the basis for awarding fees?
The basis was under NRS, drawing a little blank here.
NRS 18.010?
18020, essentially, that the defense had maintained a defense that really wasn't sustainable, and that considerable fees had been run up in the matter, and that was pretty much the basis of the order, 18010 and 18020. And this has been argued essentially every hearing that we've had.
All right. So I'm going to take counsel's arguments on the issue of fees. My inclination is to award the costs as stated in the orders. I think it was very clear Judge Jones found those to be jointly and severally, that the parties were so intertwined that he couldn't separate them out. And I understand that different parties have been joined in this case at different times, but the cost of litigation, I don't believe, necessitate the court going through and dividing up which costs go to which person, because the case is taken as a case in whole, and Judge Jones already found that those are joint and several because of the intertwining of the claims and the parties. So, but as to the fees, I do see some concern that I'd like argument on. So I understand, Mr. Harris, your argument. Perhaps the other attorneys here from Mr. Franklin and Mr. Del Casal could speak to the fees.
I could, I'll go first on this, Attorney Needham. We're talking about the hearing on January 5th, and that was the That was in front of Judge Jones. He had denied attorney fees. That was really the main focus of that hearing, but there was kind of an afterthought of interest. At that time, interest was granted as stated in my papers. And there's that hearing was recorded by video, and also I requested the transcripts. The Judge Jones did not say that the defendants were jointly liable on interest. Then we had the hearing on February 14th, and that was in front of Judge Cherry, and that was strictly about attorney fees. Again, the judge did not say the defendants were jointly liable for fees. So the orders that the judge just mentioned, the orders were proposed to counsel. Mr. Harris prepared 2 orders, I believe, one on costs concerning the November 22nd hearing, and that's really not the issue today that I can see. And then the other order was the one in dispute here was entered on February 22nd, 2023. And that one awarded, laid out the attorney's fees of $2,500. It laid out the interest. But it said initially, the initial proposed order said joint liability on attorney's fees. I objected naturally because there was no such finding of joint liability on attorney fees. And then Mr. Harris ultimately changed the order and extended the joint liability over interest as well. So that's the one that was ultimately signed, and it's the one entered. As I said, those hearings are recorded. There's videos of the hearings. The judges didn't say the word joint liability on fees and interest, so I was naturally concerned about the order, and even more concerned that the order would then extend over into interest. Because what interest is, Your Honor? Interest is on the awards, on the judgment. So if you're going to extend joint liability on interest, you're basically saying the defendants are liable for everything in this case. That was never found. But what was really concerning is the papers here by the plaintiff just make multiple statements that the court actually ordered joint liability for fees and interest, which they did not. And those are statements of fact. They're not argument. They're not even supported by the record. They're not supported by the transcript. So in regard to, that's my concern initially. There was no finding of joint liability on trouble by the fact that was in there. In regard to attorney's fees,
Counsel, let me just interrupt you. So your understanding is the award is the interest is only on the fees or on the monetary judgments?
No, the interest would be on the awards.
Okay. So the interest is on the awards. Why is it controversial that prejudgment interest would be on the awards to each person individually? Because it was separated as to the awards, correct?
Right. There's no controversy on that. My controversy is the concept of the phrase and term joint and several liability. Okay. I'm not disputing interest. The only dispute I had is, there's post-judgment interest. That's there's no dispute there. My concern is the joint and several liability order, because that was never ordered in regard to neither attorney's fees nor interest. So that shouldn't be in the order at all, joint liability.
Okay. So
in regard, go ahead.
Let me keep going here. So your understanding is you don't have any objection to interest as prejudgment interest on the award against your client, correct?
Well, the only concern I had, as I said in my papers, the award of interest was based on an inapplicable statute. It was NRS 99.040, I believe, and that doesn't even support the award.
No. I'm just saying, as a matter of policy, you get prejudgment interest on an award after trial, starting from the time of the complaint was filed. You get prejudgment interest on a monetary award, correct?
Generally speaking, yep, I believe.
Okay, so, and I'm trying to dial down on what your lack of you've said, okay, maybe there's a statute side that didn't apply, but as I'm understanding you don't have an objection to prejudgment interest being awarded on the fees, not the fees. You do not have an objection to the prejudgment interest awarded on the award against your client. Is that correct?
I don't think there's ever been a an actual calculation of that interest on the
Okay.
on the awards. But I
Regardless of,
I don't object to prejudgment interest on awards in general. I don't object to
Okay.
that, and that's not
so
even.
then as to fees itself, then there's a concern that there was a $2,500 award of fees. How should that be apportioned? That's your objection?
Well, the objection is that there was an award of attorney's fees,
Yes, it
$2,500.
was.
There was no basis stated. When you get into attorney's fees, we got more than one defendant here in this case. So I think it's incumbent or required to really get into the defenses of each defendant. Both the defendants in this case, I could speak for Mr. Del Casal, believe that they were, put forth a legitimate defense in this case, and there was no indication that there's any frivolousness defenses, which is what you would need in this case to even grant attorney's fees. So my objection would be there was no frivolous defense in this case.
Right.
So therefore, I don't believe Mr. Del Casal should be liable for the attorney's fees.
Okay. All right. Miss, is it Alda or Alda?
Yeah, Alda Anderson.
Alda Anderson, would you like to speak as well? Would you like to speak?
I just second what Mr. Needham said. Plus, I just refer the court to the filings that we've made here in this case,
Right.
because I believe that our arguments are fully made out in all of these oppositions, as well
Okay.
as our bases for objection to what Mr. Harris is asking for.
Okay. All right, Mr. Harris, do you want to respond to what's been stated then?
Yes, thank you, Your Honor, and I appreciate it. May it please the court. Just to clarify one of the points that Mr. Needham has made that's incorrect. At the time of the hearing in January before Judge Jones, there was an order for attorney's fees that was denied as to me, but Judge Jones said, look, you need a Brunzell factor for co-counsel. I don't have a Brunzell affidavit, so I'm going to grant you leave to go and file a Brunzell affidavit with regard to co-counsel Carrie Doyle. Carrie Doyle only submitted an invoice for the trial and for no other work that he did on the case. And so by implication with Judge Jones, and what I understood was this is trial fees. You are getting the trial fees based on Mr. Doyle's affidavit. I filed that affidavit, and thereafter we had the hearing with Judge Cherry, and Judge Cherry granted the $2,500. Now, Mr. Doyle's Brunzell factors really only covered the trial time, and as was previously awarded or argued by Judge Jones, the issues were so inextricably intertwined that apportionment was impractical. And my assumption was, like any normal, reasonable person would be, that the attorney's fees should be joint and several to both, because both were at trial, both participated, and they were so inextricably intertwined, there was no way to really practically apportion as to what matter, and the fees were dramatically less than what had been incurred and what the Brunzell affidavit stated. So to me, it seemed quite clear that the attorney's fees were joint and several based upon the fact that Mr. Needham has argued over and over that there shouldn't be any fees, and we've just re-argued this a multitude of times. But based upon that, and based upon the interest, which was previously ruled on and awarded by Judge Jones, I just was trying to get a final judgment and trying to get this case resolved. They filed an appeal. They're not going to end. They keep doing this. We just can't seem to get it resolved, Your Honor. I believe that what I just want to do, and I want to get an order signed. I just want to get it done. But it would appear to me that the interest is joint and several because it cannot be divided. The costs were awarded that way, and the attorney's fees as well, Your Honor. We just like a final order for the total cost, fees, and interest, and the judgments, and to get an amended judgment on file. And that would be my argument, Your Honor, unless you have anything specifically that I can address.
I do have a question. So none of the orders from the November, January, February hearing have been appealed, correct? Just the judgment.
Just the judgment, yes.
Okay. The next thing is when you talk about interest in what you just said, are you talking about interest on the fees or pre-judgment interest for the awards that were apportioned?
Prejudgment interest on the awards was $7,000.97, and that was the amount.
So I don't see the, I mean, I don't see how that can be joint, if the awards themselves are separated as to each defendant, which they are in this case, what is the reasoning to say they're jointly and severally liable for the interest on those amounts? I don't understand how that works.
I guess that was just argued on that at that January date, and Judge Jones was just unaware of that. And this is, I guess I'll ask you this question, Your Honor. Is it more practical or feasible to have two separate judgments against these individuals and to calculate their interest separately when there is joint, several, and liability on the costs and the attorney's fees? And I think that was where my issue was. Do I have to have a variety of judgments against them, or can I encompass and encapsulate them all into one?
Well, if the judgment's already been appealed, I cannot affect that. But as to awarding, no, I would say yes. You do have to do prejudgment interest on each of those individually, because the interest of one defendant, they are separate defendants, and there were separate awarded judgments against each of them. So
what I can,
my inclination would be to separate that grant. I do believe the costs are very understandable why those would all be joint and several. That's very understandable because they were all in the case. They're all defendants in the case. You incur those costs as against all of them, right? So that's very understandable. But when you're talking about prejudgment interest and there's separate damage awards for each defendant, the prejudgment interest has to be separately calculated as to each award, because it's going to be different the interest amount is going to be the same, but the amount of, the defendants don't want to say, hey, I'm actually the same person as this other person. They are three separate defendants for the purpose of the awards that were made. So the prejudgment interest needs to be calculated separately on those awards. Okay.
And then the final would be the attorney's fees. Would they be joint and several as well? Just given, and because I'm looking at three different orders here, but that I can submit those.
So the award of attorney's fees also similar. I would agree with that on costs. Those are generally, those are the finding of Judge Jones. He did find that the parties were so intertwined. It's the same exact reasoning as you can't say, well, he came to trial for only one defendant. He came to trial for all the defendants. They were all there. And so there is joint and several liability as to those attorney's fees. My concern on the attorney's fees was how they were awarded, but I'll allow counsel to defend those on appeal. It sounds like these will be appealed anyway. But so the joint and several liability would also apply to the fees and so the fees and the costs, but the prejudgment interest is a separate issue identified as to each award separately.
Your Honor, if I may make a point that may be helpful here, because I know this gets, when you're looking at costs, you look at the memorandum costs, the itemization, and it's pretty straightforward. I think it's easy for any court to look at the memorandum costs when they got more than multiple defendants or parties at a trial. It is, and to try to apportion that, it may be difficult. Like in this case, for example, we had a jury bill. I think it was like $2,300, something like that. There was some motions for some, filing fees. Obviously, when you have multiple defendants, that may be difficult for any court to apportion. Now, that's different when you talk about attorney's fees. We don't have this memorandum of like filed items. The focus is different. I believe the focus is the actual defense of each. Now we got more than one defendant here. So I don't think we could just take the same ruling on costs and apportion on costs and carry it over necessarily to attorney's fees. It has
You're
to be
saying one party should be liable for the attorney's fees and not the other parties?
It depends on the case. It depends on each defense. Now, in this case, I'll tell you right now, because the Judge Jones ruled that an attorney's fee is not a cost.
Right.
That's why he struck so there does not, there are different items. So they're
Right.
treated differently, they're subject, so that's my response. And then your point is, how did they award attorney's fees in general? Like, what was the reason? Was there a frivolous defense or not? We don't know. The
Right.
defendants have said there is no frivolous defense in this case, so therefore there
Right.
shouldn't be. I know there was one grant. Go ahead.
But the court did award fees, and that's what plaintiff is seeking to tie it to. And so that's going to be the order. We're going to keep the fees, and plaintiff's going to have to sustain that on appeal. But it is going to be joint and several liability on the fees and on the costs, and but as to prejudgment interest, that applies to each individual award. That is separated. And the reason for that, so the reason I'm awarding this is simply, this is what the record reflects. And so I'm going to sustain that record, and there's several motions filed. The motions are granted in part, denied in part to get to this point. And, this is unnecessarily complicated for the amounts at issue for another point. But to get it legally correct, that is what the courts stated. So now, as to the finding as to why those fees were awarded, that counsel is, Mr. Harris is putting that on $2,500 on NRS 18. I do believe it's 010, but it's section 2 is what you're referring to.
That's it, Your Honor. I'm sorry.
And so, that's his basis for the award, and that's probably going to be problematic on appeal, Mr. Harris. So just so you know, but that's the way I'm seeing it right now, and I'm not inclined to. The motions that have been filed, I don't feel give me the right authority to change the rulings, other than to clarify what it was, in my opinion.
May I say something for the record?
Thank you.
Yes.
You notice that Mr. Franklin came into the case more than almost a year after the case was initially filed.
Right.
Costs are very subjective. They can be determined specifically based on the costs that the plaintiff incurred. And therefore, to have joint and several as to cost is unfair to at least to my client, in that he came in late. The filing fees would have been different. Had he been the original filer in this case, he would have had to pay the full amount in terms of the filing fee for the clerk. If he came in as attached to the case, then I don't believe there'd be any filing fee for him, since he was being added to the case, as well as the corporation. Right. So the cost there would be different as to him, and all the other costs, those can be specifically calculated as to each defendant. So for the record, again, I object to the fees, the costs being joint and several.
Right, and so for the record, to respond to that objection's overruled because Judge Jones did find the parties were intertwined. So just as a rule, if one of them's a necessary party, then they both have to be joined anyway. There's no reason to assign the greater fee for the initial filing to a secondary defendant, or there's no reason to divide those if they're both necessary parties. Excuse me, I said that wrong. You should divide those if they're both necessary parties. So the costs, and Judge Jones was very clear about this, that the parties were so intertwined and the claims so intertwined that they should be awarded joint and several. I'm not going to go through and parse those out. That was Judge Jones's finding, and so I'm sustaining it. Okay? So to move forward from this, I'm going to draft this ourselves.
Your Honor,
So, counsel, are you going to be able to draft an order based on that, or do I need to do it myself?
Yes, Your Honor, I will draft an order, and I'll draft several proposed orders on
No,
each
I
individual.
don't want several proposed orders. What do you
no.
want several proposed orders for?
Oh, I'm talking about for the judgments, Your Honor. I'm trying to get the final judgment in on this. So I need a final judgment with regard to I'm sorry, Your Honor, with regard to the interest and the jury amounts with each individual client or defendant, and then an order with regard to the remainder. So if that makes sense, one general order and then specific orders for each defendant. So it should be 4 orders, the way I understand it.
All right. If that's what you're looking for is the final judgments, then yes, go ahead and proceed on that.
Your Honor,
And
I
there,
just want to clear. Go ahead.
there was some objection about putting an amended judgment on there. So that was my standard, normal way of doing final judgments. But I'm not sure exactly what you'd like titled, how you'd like it titled, Your Honor.
If it's supposed to be a final judgment, then issue it as a final judgment.
Very good.
Your Honor, just to
May I ask
clarify.
something?
Oh, go ahead, Alan.
Go ahead, Mr. Needham.
Yeah, thanks. I know there was orders already in place right now, the one that's the subject order of today. How do we handle that? I'm thinking that could be either amended or, that's the one that says this combined lump sum of interest, which the court said was not, we need to do an amended order on that to correct that. That's one way of doing it, correcting that particular order as to interest that the court just said that's separate on the awards for each defendant. And it's not, as I understand, that's not joint liability on interest. It's only on cost, and the court today mentioned it's on fees, I believe.
That's correct.
So I believe the order itself that stands could just be amended order, and that would be one document, and then Mr. Harris wants to do an amended judgment. We already have a final judgment, and then I see only the need for 2 documents. And then an amended judgment that would kind of be a correct outline the correct rulings here today.
So you already have a judgment. Was the judgment is what it's appealed, the October judgment? Has that been appealed?
Yes, that's on appeal. That was October 13th, right?
I don't know if I have any authority to amend that. If you've already.
Well, I think Kurt Harris wants. Yeah, that's probably a good point, Your Honor. I don't know if it's necessary to do an amended one. I think Mr. Harris is trying to achieve some sort of consolidated document that has, like an omnibus or consolidated document. I think is what he's trying to achieve, but I'm not sure if that's necessary. I think an amended order here today, just setting forth these rulings and clarifying the court's clarification, I think that should suffice.
Okay. Mr. Harris, what do you think?
Well, again, Your Honor, I'm trying to get the judgments on the costs, the attorney's fees, and the interest. I'm entitled to a judgment on that. If this order is going to be stated as a judgment, that's fine with me. But I think counsel's obviously trying to avoid a subsequent judgment being awarded here, which is what is appropriate after cost, fees, and interest are awarded. I'm not really sure where the disconnect is.
We've already got there's already an order on costs already on file, Your Honor. It was March 1st, I believe. It was. That's not even. There's already one out there entered on costs.
Well, your
Maybe it was
motion
March
was to
1st.
resolve that order, wasn't it?
No, there was a separate order on costs regarding that November 22nd hearing, and that was already entered by the court on March 1st, I believe. Yeah, March 1st order on costs. It was so that one. It seems like the court is affirming. There's not an issue there.
May I make a request?
So.
Sure.
I know I see that you're a little bit tired of this right now.
I am.
And I noticed that. But this is what's going to happen. My client has not paid for a long time. And one of the issues here is this case being dragged out unnecessarily. What you've heard right now is the fact that Mr. Harris is going to prepare the order, send it to my office. There's going to be some objection. It's going to send it to Mr. Needham. There's going to be some objections, and it's going to be going back and forth. And what we've increasing is the same thing we're concerned about. Is the increasing fee. I would propose that the judge knows what the judge ordered, and I would request that the court prepares the order so that if there's any issue as to it's not right or it's not wrong, then the court does it, and then they have an argument with the courts, not with each other.
All right. So that is, fortunately, I do agree with Miss Alda here. I feel that council has proven themselves incapable of doing this together. So I will, the court will prepare the order. Mr. Harris, I'll put upon you to submit affidavit by Friday to the court as to the fee, as to the interest as you've calculated it, and anybody else would be welcome to submit their affidavit for their, if they have anything. So I'll give Mr. Harris, I'll give you till Friday to submit your affidavit for what the interest is and the calculations of that, and all the other parties you'll have until Monday to submit, and then on Tuesday we'll have this in chambers to issue an order. The case.
Yeah, Your Honor, just one request. Could I have until Monday? I'm out of the office and wouldn't be able to get it done until Monday.
All right, so you'll have until Monday to submit your affidavit of what the cost should be. Then I'll give opposing counsel till Wednesday to submit their affidavit of what it should be, and then the court will issue the ruling on the Friday. So that'll be Friday,
That's
the 21st.
and that was an affidavit on interest, not cost, though, correct? On interest.
Yeah, on the interest. The cost has already been determined.
Understood.
No, and just, it may be helpful to Mr. Harris when he's doing his affidavit, I believe, and for the court, I believe when you calculate prejudgment interest, I believe there's rulings out there that you only need to determine the rate at the time of the judgment was entered on October 13th, and you use one rate at that time. You don't go back and every 6 months and change it. But that's my understanding. There may be something there to alleviate the tediousness or the burden of having to recalculate every 6 months. So you may want to look. I'll just throw that out there.
Sure.
For simplicity's sake.
Thank you.
Thank you.
Thank you, Your Honor.